High Court has consolidated 7 petitions challenging the removal of Chief Justice Martha Koome and other judges of the Supreme Court, issuing key directions aimed at streamlining the proceedings. A pre-trial session held on Friday, the 3-judge bench granted Chief Justice Martha Koome and her colleagues additional time to amend their petition in response to the consolidated case. The 7 petitions, which were initially filed separately, have now been merged into a single case. The court also extended the conservatory orders barring the Judicial Service Commission from proceeding with the removal petitions. These orders will remain in place until the matter is fully heard and determined. The case is scheduled for mention on the 4th of July 2025, after which the court will set dates for the highlighting of submissions.
In terms of housekeeping issues,
yes.
Number 86 and 89 have just been.
Elsewhere, in a move that has sparked legal and political speculation, former Deputy President Rigathi Gachagua, along with 3 other petitioners, has withdrawn 4 key court cases that challenged the legality of his impeachment. The move comes in the wake of a Court of Appeal ruling that declared the appointment of a 3-judge bench by Deputy Chief Justice Philomena Mwilu unconstitutional, a bench that had been slated to hear Gachagua's petitions. His legal team now seeks to have those withdrawn cases exempted from that bench altogether, raising fresh concerns over judicial composition, forum shopping, and political strategy through the courts. So what does it all mean for the integrity of Kenya's constitutional process? With us in the studio tonight to unpack these developments is Professor Muigai Akech, a constitutional law expert and respected scholar on judicial processes and executive accountability. Professor, always a pleasure. Thank you for speaking with NTV tonight.
Thank you, Michelle.
So let's begin here. What is your interpretation of the High Court's ruling last week?
Essentially, what the High Court was saying, so first of all, just to set the scene, the High Court said, the Court of Appeal, the Court of Appeal said that what the Deputy Chief Justice did was unlawful. And what did the Deputy Chief Justice do? The Deputy Chief Justice exercised powers that under the Constitution can only be exercised by the Chief Justice. And what is this power? This is a power to empanel a bench of judges. The Court of Appeal said that only the Chief Justice can do that. In law, when somebody exercises a power that they do not have, it is as if they never exercised that power. It is as if that which they did never happened. Then the disappointing thing about the Court of Appeal decision is that it then failed to tell us what are the consequences, what is the import of its decision that the Deputy Chief Justice exercised a power that she ought not to have exercised. And that import is fairly obvious to any lawyer. I tweeted about these on X, and I've heard all kinds of stories from lawyers. It's very simple. It means that we go back to the status quo ante. What was the status quo ante? The status quo ante is what the High Court in Kerugoya did. The High Court in Kerugoya issued conservatory orders, which were meant to preserve the then status quo. The then status quo was then Deputy President Gachagua trying to preserve his position as Deputy President while his petition was being heard in court. Now the court in Kerugoya gave him those orders. When this unlawfully empaneled bench sat, I believe on the 31st of October 2024, it issued a decision overturning the decision of the Kerugoya court. So we go back to the status quo ante, which is when this court had not sat. This illegally or unlawfully constituted bench had not sat. It means that as we speak, the correct position in law is that Gachagua remains the Deputy President.
All right. So from a constitutional standpoint, does this raise conflict of interest concerns? Because that is what Gachagua's legal team has done, saying that they're withdrawing their 4 main petitions. They specifically want to exempt those petitions from this 3-judge bench. Is there a valid conflict of interest concern here, especially when the new reconstituted bench has the same faces, for example?
So two things. First of all, what is happening is just procedural. The withdrawal of the petitions, they're withdrawing the pre-impeachment petitions,
right,
not the post-impeachment petitions. And they're withdrawing them because the post-impeachment petitions cover the same issues that they wanted to address in the pre-impeachment
right,
positions. That is number one. But number two, with respect to, your question was?
Is there a conflict of interest issue?
No, there's no conflict of interest. I mean, there's no conflict of interest at all. The problem is that, look, the 3-judge bench that sat unlawfully issued certain orders that now do not sit very well with a huge segment of the public. So, and then now you're asking the very same bench to sit. It does not augur well. I think the neatest thing for the court, for the Chief Justice to do now, the Chief Justice has to do 2 things. The Chief Justice has to come and tell us that, look, here is what happened. Here is why the Deputy Chief Justice, right, exercise these powers when she ought not to have done. But number 2, that bench cannot sit. And that bench cannot sit for 2 reasons. Because if you read the judgment of the Court of Appeal last week, they were saying a very important thing. That, and in law, we say that justice must not only be done, but it must be seen to be done. And what happened here is that there was no information, there was no accountability, there was no transparency on the part of the exercise of that power. Because what we envisage, I mean, it's not always going to be the case that every power must be explained. A police officer arresting you sometimes, arresting somebody committing a crime, somebody shooting at another cannot be telling them that, oh, look, wait a minute, please stop shooting, let me explain to you. But there are certain circumstances where an explanation must be offered. If the Chief Justice is impaneling a bench, the Chief Justice must be able to say that I'm appointing these 3 individuals for ABC reasons. If the Chief Justice is not able to say, the Chief Justice must be able to say that I am delegating, assuming that it's allowed by the Constitution, I'm delegating this power for ABC reasons. They've not done that. So to come back and tell us that it is the same bench would not be very good. But also, the decision of that bench is very problematic. And I personally do not agree with it, because it's making certain pronouncements that do not make sense logically to me as a lawyer. Because it is saying its decision to vacate the orders of the Kerugoya High Court was based on a fallacy. What is this fallacy? That so the court is telling us, and you can read yourselves, the court is telling us at paragraph 139, right, that the Constitution does not envisage any scenario in which the office of the Deputy President would be vacant. And so it is making the claim that the office was vacant. And that is why it is vacating the order, because the Constitution cannot have a situation where the office is vacant. But vacancy, when there is a claim that the process of impeachment was unlawful, is a determination that a court has to make. Okay. There was no vacancy. You cannot say that there's a vacancy, yet Gachagua has filed a court case. A vacancy only arises if the Deputy President was lawfully and procedurally impeached, and that is precisely why Gachagua is in court.
Yes. I'd like to see what is happening with the Supreme Court itself and the 7 judges and the petitions to remove them. But what does this mean now for the future of the impeachment case against Gachagua, even the withdrawal of these cases now?
You mean what is happening in...
What does the import of this case mean on the proceedings of Gachagua's impeachment? Where does it leave the impeachment process now?
You know, I think it puts Gachagua in a very, very strong position, because as far as I'm concerned, he remains the legitimate, lawful deputy president until his case is heard and determined.
Okay.
It means that Kindiki is the illegitimate deputy president.
Let's move to the High Court. The High Court has consolidated the 7 petitions challenging the removal of the Chief Justice and other judges of the Supreme Court. The session held today, the bench granted the Chief Justice and her colleagues additional time to amend their petition in response to that consolidated case. What do you make of that decision and the implications of it? Again,
these are procedural motions. I think the fundamental question that is problematic with these petitions against the Supreme Court justices is that we are heading towards a constitutional crisis, because our constitution never envisaged a scenario where you have petitions that want an entire bench removed from office, and the Supreme Court at that. And then you have a scenario where the Constitution again says that only the Chief Justice can empanel a bench. Again, the parties have asked the Chief Justice to empanel a bench in this matter. She has done so. But it is very problematic. She's going to be a judge in her own cause. As we say in law, no one should be a judge in their own cause. The Latin rendition is nemo judex in causa sua. How can the public then see that there's going to be any fairness in the determinations that are made out of this process? The Chief Justice is a litigant, and yet the Chief Justice is choosing, irrespective of what the Constitution says, is choosing the people that are going to make to determine the case. I think there's a problem there, and one of the things that I think we need to look at in terms of amending the Constitution of 2010. Right.
Now, many of these cases have come out of what people say has been judicial impartiality, or perhaps perceived overreach within the judiciary. What is your assessment of why we're here today?
I don't think it is judicial overreach as such. If you look at our Constitution, it's very transformative in many respects. It gives the High Court very wide-ranging powers. As long as any entity, whether it is in the judiciary, whether it is in the executive, whether it is in the legislature, exercises their powers unlawfully or in ways that violate the Constitution, the courts have jurisdiction.
Finally,
rightly so.
What are your expectations from Chief Justice Martha Koome and her handling of the situation?
I think one is communication, because justice is about perception fundamentally. It's about perception. In the empanelment by the DCJ that has now been held unlawful by the Court of Appeal, I think the Chief Justice ought to have spoken by now to explain. She owes the public a duty to explain. Even in our own case, she owes the public a duty to explain. Because yes, we are dealing with rules, but we're dealing with the rule of law. The rule of law is something that must be seen, something that has to be substantive. It can't just be that we say, well, the Constitution says it's only the Chief Justice that can empanel benches, but she's a party to in these cases involving the Supreme Court justices. Surely she must be able to explain, because she wears two hats. She's not just a litigant; she's the head of the judiciary.
All right,
and
Professor,
we expect that justice must be dispensed in a way that will lead the public to perceive it that way.
Absolutely. Professor, yes. Many thanks for your time tonight. Professor Muigai Akech is a law expert and respected scholar on judicial processes, speaking to us about the Supreme Court petitions consolidated, 7 of them consolidated, with challenging the removal of the Chief Justice and other judges of the Supreme Court. Let's take a break here on NTV Weekend Edition. Much more still to come after the break. Just stay with us.